Welcome to Aspen Leading Edge. I'm Patty Roberts at St. Mary's University School of Law. Today's two guests include David Sklansky. He's the Stanley Morrison Professor of Law and Faculty Co-Director of the Stanford Criminal Justice Center at Stanford Law School. And Andrea Roth. She is a Professor of Law and Barry Tarlow Chancellor's Chair in Criminal Justice at Berkeley Law. Welcome to you both.
Thanks for having us.
Good to be here.
Well, I'm very excited to have you both so that we can talk a little bit about teaching evidence. And I want to congratulate you on your new edition of Evidence, Cases, Commentary, and Problems, the 6th edition that was just published this semester. And so why don't you start by just telling me what prompted you to write the 6th edition and how people who are considering teaching evidence or changing their case book might want to consider the 6th edition.
Well, David started all of this, so I don't know, David, if you have anything you want to say about why you wrote an evidence book to begin with. I know why I love joining it.
Well, the 6th edition is vastly better than any of the previous editions, and both the 5th and the 6th editions are both better than the previous 4 editions, which I wrote without Andrea. But the reason why I initially wrote an evidence book was I wanted something that was easier to teach out of and more rewarding to teach out of. So I wrote the book because it's the kind of book I would want. And I found that lots of other people seem to find it valuable too. And then over the course of several editions, we've incorporated ideas and suggestions from lots of the people who use the book. And I think that's made it stronger. And then Andrea brought a whole bunch of expertise and perspectives to the book that I didn't have, and that improved it. Revised the book this time, partly because evidence is a field in constant flux. There are new rules and new technological and social developments that revise the way we need to think about the rules of evidence and revise the way it's taught. So we wanted to incorporate that. We also, as we've taught the course and as we've talked to other people who teach the course, our ideas continue to develop. We wanted to include more materials relating to issues of gender and race than we had in previous editions. And I wrote a law review article a couple of years ago complaining about the fact that all the leading evidence books, including ours, did not include what I have come to think is a pivotal hearsay case from the early 19th century. And having made that argument, I felt like, well, we should put it in ours. And Andrea was kind enough to agree that we could do that.
And why was it missing from so many books? And what prompted you to write the article?
So I think it's missing from books because it's an embarrassment. And it's an embarrassment because it was a slave case. It is a case in which the Supreme Court used the hearsay rule to exclude evidence that was offered by two plaintiffs who were challenging the legality of their enslavement in early 19th century Maryland. And this case is actually, I think, the case that more than any other signified the transition of the hearsay rule in the United States from a kind of a loose principle of preference for in-court testimony to what we have today, which is a rigid rule of exclusion subject only to a bounded series of exceptions. And for many years, actually for well over a century, this case, Queen versus Hepburn, was regularly cited as the chief authority for the hearsay rule and for the unforgiving nature of the hearsay rule in the United States. It's less often cited today because people are properly embarrassed about it. But I think it's important to remember the case for a bunch of reasons. It alerts students to the fact that the hearsay rule, although often a shield against injustice, can itself be an instrument of injustice. It is a reminder of the fact that the institution of slavery wound up getting wrapped into and influencing the development of virtually every doctrinal field of American law, including fields that you don't normally think of as influenced by slavery, like evidence law. And it's also it's a good teaching vehicle because it is short, it has sharp facts. It's something that students are interested in.
Well, bravo for including it so that people can see the historical setting upon which hearsay was developed. So, Andrea, you got the call. You got the call from David. And what was that like? And why did you join the book? And what has been exciting for you about joining the book?
Best day of my life. Best thing.
If you have a spouse or partner,
I know he won't hear this podcast first, at least. We can edit that out. So I think one of the beautiful things about the book, and this isn't something new in the 6th edition, is how David already infused it with a law and technology vibe. That he already had this chapter on probabilistic evidence and spent more time on forensic evidence and the expert testimony issues, sort of knowing that that was going to be a key difficult topic for judges and law students and law professors going forward. And he's written on it, the scientization of proof. So I think that's one of the reasons that he's one of my mentors to begin with. And it's also a reason that it's very natural for the 5th and 6th editions to double down on all of that. It wasn't just some new add-on because here we are in this AI moment. It was the book among evidence books that had already taken a lead on those issues. And I guess the 6th edition, I guess what I would say is that the 5th edition, I think we added a lot on, machine generated proof and some of the digital evidence and things that were just coming to the fore, where judges were just trying to figure it out. And some of the rules had, just been changed to deal with it. And the 6th edition, I think, reflects the fact that judges have had a few years to decide what they think. And some of these issues have percolated a little bit more. And so that's why we added 70 new cases, because the case law on some of these new issues is richer than it was when these things first came on the scene. And that's honestly why the 6th edition, I think, was more laborious, because there's just so much more case law on these new issues than there was. And it requires, I think, expertise to go through and figure out what students need to hear in that big pile of new cases. And it's really fun, because the reason we're experts on these topics is that we're passionate about them. So it was labor, but it was a labor of love. For sure.
Terrific. So when you talk about adding 70 new cases and looking at this whole new landscape of legal scenarios within which our evidentiary system has to operate, artificial intelligence, rap lyrics, deep fakes, all of that, where, as you cut off the 6th edition, because we always have to find a stopping point, right? What unanswered questions do you think remain in the rules of evidence right now? And Andrea, maybe you can talk about your role on the advisory committee for the rules of evidence. What is it that evidence scholars are really struggling with still?
Well, they're definitely still struggling with all the old questions. Should Rule 609 exist? Things like that. But with respect to some of these new questions, I think a couple of the things that the advisory committee is struggling with, and that's because they're hard questions, is number one, let's say deepfakes. Is it a new iteration of an old problem, or is it truly qualitatively different from what has come before? So I think there are some who think, deciding whether handwriting is a forgery or is authentic actually can be very, very difficult. And deepfakes are just another example of that, where a forgery can be very, very difficult to determine. It doesn't mean that we need a new rule of evidence, 902.1 for deepfakes. On the other hand, there are people who feel like, actually, this is really qualitatively different. We are in a different world, and there has to be some new threshold. So far, the advisory committee has taken the former view and has said, look, deepfakes, it's just a regular application of the old rule of authentication, but we will expect that this will be more of a fight with respect to videos now. Another thing they're struggling with is machine-generated evidence. And when that evidence is in the form of what you might call an opinion that looks a lot like an expert opinion from a human if it were uttered by a human. And I guess two questions come out of that. Number one is, what happens if the output of a machine truly is not accompanied by the testimony of a human expert? Right now, that would technically mean that it is not covered under Rule 702. And so the advisory committee is considering what I think of as a somewhat modest fix, like a new Rule 707, let's say, that would subject machine output to Rule 702 if it's the type of output that would be subject to Rule 702 if it were uttered by a human expert. But the other part of it is whether or not you've got a human expert. If you've got this big complex algorithm that is saying, yes, this was the cause of death, or yes, this is this person's diagnosis, or yes, this person was a contributor to this DNA mixture, yes, this person wrote this note, then to meaningfully be able to scrutinize that evidence, you really need more than just cross-examination of a human expert. And I mean, David has written on these issues well before I have, but you may need the prior output of the machine. You may need pretrial access to the machine. You may need to condition admission on the fact that licenses to these proprietary algorithms are available to independent researchers and things that are unique to algorithms that can't be cross-examined the way that a human expert can. And so I think the advisory committee so far has dealt with those issues more in the advisory committee note to a draft rule. And then they're, I think, hoping that the rules of discovery and the Jinx Act and some other things might deal with those other issues. And, the rules of evidence can't do everything, but these are some of the things they're dealing with.
And David, what are your personal thoughts in your scholarship and research for machine-generated evidence? Do you think new rules are necessary, or is our existing system prepared for that?
Well, I think we need new rules for thinking about digital evidence generally, and the courts continue to struggle with how to think about digital evidence, and that's why we have a bunch of new cases about digital evidence in the 6th edition. I think related to that is the question of what used to be called demonstrative proof, but the advisory committee calls illustrative exhibits, things that in theory aren't really evidence in some sense, but they're used in the courtroom and maybe they're given to the jury. And we now have a rule on illustrative exhibits, but it doesn't say a whole lot. And courts are continuing to try to figure that out. And I don't think that this is the last word on that rule. So I think we're going to see more of that. I think there are a bunch of new cases in the 6th edition also about character evidence, which continues to be a problem, particularly with regard to cases of sex crimes and child sexual abuse. There are new cases on confrontation, both with regard to the Crawford rule and with regard to the Bruton rule, which the Supreme Court continues to wrestle with. And I think privileges are another area where the courts are continuing to wrestle, including the Supreme Court. One of the many cases that we've included in the new case that we've included in the 6th edition is a portion of the Supreme Court's opinion in the Trump immunity case. I think from the perspective of evidence scholars, the weirdest part of that opinion was the part where the Supreme Court said that presidents not only can't be prosecuted for their official acts, but their official acts can't be used as evidence in prosecutions for their private conduct. And it's very, very hard to understand what the court meant by that. I think they got themselves in some trouble because they weren't thinking very clearly about privileges and what they are. And my guess is that most evidence scholars have that view. And so despite all the negative things you could say about it, that portion of the opinion is at least a good teaching vehicle, and that's how we're using it.
I'd also say that we've added a lot of problems. And one of the things that I think distinguishes this book from other books and why I used it well before I joined it was that it's really that sweet spot between there are case books and there are problem books in the evidence sphere. And I think this book really is that sweet spot between, tightly edited cases. And the beauty of cases, as David pointed out to me right when I was starting evidence, is that they really happened. They're not just hypotheticals created by a law professor, but they really happened with real people. And yet problems can be very helpful to go straight to some of these issues that you really want students to think about to be able to apply the rules. And so there are scores of problems, and we've added some new ones to deal with the most, I guess, some emerging issues that they're going to have to deal with. And now in the 6th edition, I think we've got the best teacher's manual also, in part because, again, when I met David, or shortly after I met him, he had already received the Distinguished Teaching Award at Berkeley. And everything I know about teaching, I've pretty much learned from David. And so I think we think very deeply about pedagogy and how to choreograph each class to get the most of it with the tightly edited cases we have.
If I could just say something about the teacher's manual, which I do want to brag about a little. So Andrea and I both care a lot about teaching. Andrea not only has received the Distinguished Teaching Award at Berkeley, she also has chaired the committee to decide who else deserves that award. So we both care a lot about teaching, and we spend a lot of time on the teacher's manual. The teacher's manual really isn't an afterthought. And a lot of adopters have told us that they particularly value the teacher's manual because we explain how we teach the material. And we're pretty concrete about how to set things up in class, different ways you can approach the problems and the cases. It means that there's a lot more work when we revise the book, because we not only need to revise the book, we also need to revise the teacher's manual, which is really a separate book. But it's important to both of us. It also helps us be better teachers because it forces us to think about exactly how we think this material should be used.
Well, I'm glad you both mentioned the teacher's manual because Aspen describes it as extraordinarily strong. So I was going to ask you about it anyway. I haven't seen those adjectives used with a teacher's manual description before. So bravo. I'm sure your adopters do appreciate that. Now, tell me, you both seem very passionate about the topic, and I love that, David, you were a mentor to Andrea. Now, you're both exploring these new issues together. Why do you enjoy teaching evidence?
I can start, but we may have some of the same reasons. We were both trial lawyers, which I think is, on different sides of the aisle. So I think you can see that in the book and how the problems are written. And so we kind of have a sense of, I think, how if you actually know the rules of evidence, how they work in a courtroom, not only is it fun because trials, notwithstanding all of the tragedy and everything, I mean, there are fun aspects to jury trials, let's admit it. And rules of evidence are part of that. It's also one of those courses like tax law or something where the rules, they seem so dry, I think, to some students when they first come in or see it in the course catalog, but it's so embedded within the rules, all of these decisions we've made about who should be deciding facts and how should we adjudicate cases and do we believe in redemption and, all of this really deep stuff that once you unpack it for students, I feel like it comes alive for them as well. And so I think there's something rewarding in taking a subject that they think is going to be dry and just showing them how rich it is.
I think it's rich partly because it sits at the intersection of institutions and some fundamental problems of social life. A lot of Anglo-American evidence law is shaped by the institution of the Anglo-American trial, but it's also motivated by concerns that are universal about how do you decide things in a diverse democratic society when it's really important to be as careful as you can about getting the answer right. And there are things that where there's sharp disagreement. And I think particularly today, when the whole idea of shared rational discourse can seem under assault, it's fairly remarkable that people who serve on juries continue to leave with a much more favorable impression of the jury system than they had coming in. And I think that that's because, with all of its faults, and boy, are there lots of faults with our evidence system. But for all of its faults, there is something that works about the idea of getting 12 people together and having them sift through the evidence. And it works in part because of how trials are structured. There's lots of things that are wrong about how trials are structured. But I think all you need to do to appreciate the rules of evidence a little more is watch some exercises in fact finding that aren't governed by the rules of evidence, like a congressional hearing or a presidential debate, and you get more appreciation for it. I'm going to be teaching out of the 6th edition for my own evidence course, which I'm starting a week from next Monday. And I think I'm going to start with a clip from the presidential debate last year where Donald Trump was arguing with one of the debate moderators about his claim that immigrants in Springfield, Ohio, were eating people's pets. And you can see the frustration of the moderator in trying to figure out how we can bring this discussion somewhere back within the realm of rationality. And it's a way of, I hope, of getting students to start with an understanding of what this whole enterprise is about. So there's that. And then there's the long history of these rules, which is often colorful. There are trials themselves, which sometimes are often tragic and heart-rending, but also can be entertaining and interesting for students. And there's the whole question about American legal culture and the role of the lawyer and the role of the judge, the role of expert witnesses, how law enforcement witnesses are treated. There's just so much in the course that's interesting. I'll say one more thing, which is I think students often come to law school thinking that they're going to learn about these arcane rules, which can result in counterintuitive results and no one but lawyers understand. And then they go home and they're talking to their friends or family after a semester, and somebody says something like, "So, when are you liable for damages that you've caused another person for your carelessness?" And the students will say something, "Well, when you've been unreasonable, I guess." And then they stop and they think, "Wait a minute, is that all I've learned in torts?" And they feel like they want something that seems a little crazier and more obscure. And boy, evidence is the course that delivers that.
That's funny. I thought you were gonna say the student, when they go home, says, "Well, it depends." Well, thank you so much, and congratulations again on Evidence, Cases, Commentary, and Problems 6th edition being published. I want to also mention the 6th edition is through Aspen Publishing. But David, you've been busy. You had another book published in this last year, Criminal Justice in Divided America, Police, Punishment, and the Future of Our Democracy, published with Harvard University Press. You want to just share for a minute or two what readers could find in that book?
Sure. That book actually overlaps in some ways with our case book, because it's about how to think about criminal justice in a time of division. And part of it is about how we should think about trials and about the need, both in trials and in thinking about institutional reform of police and prisons and prosecution, to take into account the fact that we're a diverse society. People have different backgrounds and different opinions. My view is that if we're going to fix criminal justice, we need to take that into account. And I also think that if we want to remedy some of the divisions in our society, we need to fix criminal justice, because criminal justice is responsible for some of those divisions.
Well, thank you so much. I'm going to now ask the final question of both of you, and maybe Andrea, you can start. But I like to ask all my guests what your predictions are for the future of legal education in the coming decade.
Wow. Don't hold me to any of this, but I mean, I think this will come as no surprise, but part of what we're going to have to do is figure out AI. That ship has sailed. It's coming, it's here. We need to deal with it. And a couple of things come out of that. Number one is that students will need to know how to use it as a tool while still thinking critically themselves. I'm having to do closed book exams now to make sure that students don't use ChatGPT on their exams so that I can assess how much they've learned. But as lawyers, you're going to have to know when to use it and when not to use it, how much to trust it, and in what contexts. And all of that is going to be a key skill, and it's going to change rapidly even from today to 5 years from now. But the other broader thing that raises, that law students, and I mean, you as a dean have to think about this stuff more than I do, is what are humans good at? There are going to be some legal skills that just will be perhaps better done through automation, and we can't be ostriches. At the same time, we are an adjudicative system of humans. It is a system of moral judgment, and you can't delegate moral judgment to a machine. And even in the classroom, like we're going to have to think about, students are going to say, well, why can't I just take this class at home remotely? Post AI, post pandemic, we're really going to have to think really hard about what a live classroom and what human rendered justice still has to offer. I think it has to offer a lot. In fact, our very humanity is at stake. But we're going to have to make the case, and that's going to require some hard thinking that we haven't had to do before.
Yeah, and I'll just add that sometimes people talk about AI being able to replace pretty much everything that people do when they're sitting at a computer. That's the prediction of what these systems will be able to do, say, in the next decade or so. So a trial is not something you can do just sitting at a computer. And particularly in Anglo-American trials have always been centered around human encounters. I mean, that the Confrontation Clause enshrines this in the requirement for face-to-face encounters. The jury system is about encounters between people with different views working together to figure out facts. The whole trial process involves lawyers, and something that they can't do just sitting at a computer. I'm not sure how legal education is going to change in the next 10 years beyond what Andrea has already described. But I do think that part of focusing on what people are good at and what can't be replaced and what lawyers can bring that machines can't will involve thinking about the trial process. And evidence law, I think, is a subject that, if anything, will become more and more important.
Well, I want to thank you, Professor Sklansky and Professor Roth, for discussing Evidence, Cases, Commentary, and Problems 6th edition that just came out with Aspen. And also for sharing with us your enthusiasm for the subject and why it remains so relevant and maybe more relevant than ever. If you enjoyed this discussion with leaders of the Legal Academy, I hope that you will listen to additional episodes of Aspen Leading Edge podcasts that you can find on your favorite podcast channels. Thank you.
Thank you, Dean.